start the recording.
That's good.
Multi-speaker gallery. Okay.
I think Spotlight is for if we were going to let I think if we three are, Jake, Christopher, and I are on video and unmuted, that's all you need. Like, I don't think you need to give us a special designation. That's what you need. I think the Spotlight's for if you want to let somebody talk, like a questioner, I think. Is
Okay.
that word with? Is that what you want? Okay.
Yeah, I was kind of wondering if there's a way that I can format the screen so that everybody sees the screen the same way, but it doesn't look like I can.
Okay.
All right, we're at 6. Should I start?
Give me 30 seconds. I just want to write something, just jot something down here.
What'd you draw?
I'm just
Not bad.
I'm not doing a drawing right now. That's funny. No, I'm writing just a couple jogging words from my phone so that when I'm introing right now, I don't have to look at my phone. I just need one more second. Hold on. And first question.
Okay, and we've got 26 people waiting.
Okay, great. And then don't forget, Kelly, that when you let them in, you might hear a cacophony of noise if they are not muted as they should be. So you might have to hurry up and mute everybody under participants, and that might mean you need to unmute us three.
Okay, sounds good. I'm gonna go ahead and admit.
Okay. Hi, everybody. We're just admitting people from the waiting room. We'll just give it a few more seconds to populate. Okay. Hi, everyone. Some of you may know my face already. I'm the NhRP's communications director. I'm a little dark right now, a little bit in shadow. Hopefully you can see me all right. I first wanted to say thank you all so much for being here with us today and following along with the court case and all our litigation and advocacy. It means the world to us that you're here and that you're here with us every step of the way. So I'm Lauren. We have also here hosting Kelly Holt, our digital director. She's sort of running things behind the scenes. We also have Christopher Berry, our executive director. And we have Jake Davis, the attorney who argued, the NhRP attorney who argued the Colorado elephants case in October. And he's the arguing attorney on a number of our cases. Yeah, and I just wanted to give you guys a heads up about the format today. So for the first 20 minutes or so, Jake and Christopher are going to answer a few questions from me and just give an overview of what the hearing was about and what the case is about and who our clients are. And then we'll open the floor, so to speak, to questions. And we're going to pull those from the chat. And you're welcome to start putting questions in the chat whenever they occur to you. And then we'll answer those in the second half. We'll pull as many questions as we can. And if we don't get to them all, if we have a lot we couldn't get to, we'll answer them later in some fashion. Yeah, okay. We shall get started then. Okay, my first question is for Jake. Jake, can you begin by telling us a bit about who our clients are in Colorado?
Sure. So our clients, Missy, Kimba, Lucky, Lulu, and Jumbo, are 5 wild-born female African elephants imprisoned at the Cheyenne Mountain Zoo, which is in Colorado Springs, Colorado. All 5 elephants are somewhere between the ages of 40 and their mid-50s. And again, they were born in the wild and they were taken from their homes, and they've been moved around through a number of different circuses, zoos, and other types of institutions since they were relocated from their home countries to America. We have video footage of all 5 of the elephants engaging in stereotypical behavior, which is indicative of extreme stress and anxiety as a result of their sterile and impoverished environment at the Cheyenne Mountain Zoo.
Thank you. Okay. I now want to turn to Christopher. Christopher, could you tell us a little bit about the legal theory of the case, like specifically what habeas corpus is about and how exactly it applies to these elephants?
Yes, and thank you. Thanks, Lauren and Kelly for helping to set this all up, and thanks everyone for joining. It's really great to see engagement and to be able to reach so many people. So it's interesting, like when we do, talk with like media consultants and stuff, a lot of the feedback is, avoid legal stuff because it can be kind of like confusing or dense. Especially when lawyers talk about it, because we like to get very jargony. So I think the legal theory in the case though is actually like can be very simplified. And so going back all the way back to the Magna Carta, there was a thing created called habeas corpus, which is a mechanism, right, to protect individuals from unjustified and unlawful captivity, right? So just someone's holding you, like the king's holding you in a dungeon and doesn't have a good reason for it, you can use habeas corpus and say, hey, I shouldn't be there. And that's essentially what we're arguing here on behalf of the elephants, right? That their captivity in the zoo is unjustified. And the reasons for that is that, I mean, it's essentially taking their life away, right? All the enrichment, all the choices that they get to make to enjoy their life, it's gone. And it's to the point where, as we alleged, we had evidence of this in our case, right, from elephant like cognition experts, that the conditions and that just being in confinement at a zoo, it creates boredom, stress, frustration, to the point of actually causing brain damage, right? Depression, that it's just not, it's not justified to keep the elephants in the zoo. And so that is just a really simple and straightforward way of understanding the legal theory.
Thank you. And some of you may have seen my dog make a flying leap behind me onto his bed, so he's here too. And Christopher, really quickly, could you also explain the common law aspect to the case?
Yeah, so that's really important because, right, if you remember like the Schoolhouse Rock video, right, how a bill gets made, there's sort of the main way that people think about creating law is through, Congress or state legislature writing a bill and then enacting it, and then there's a statute, right? And what the common law is it resides within the judicial branch, and the judges, let's see here, a good way to put it is that they're stewards of the common law. So we have these common law principles and judges are stewards of it. So in Colorado, for example, which is where this case was, recognizes a common law habeas corpus, which means that it's something that judges tend to. And so when we say that, when we file this petition for habeas corpus and we say, well, this elephant captivity is not justified, right? They didn't commit any crime, like it's taking their life away, they're experiencing all these negative effects. Even though that's never been used on behalf of an elephant before in Colorado or or going back, that the judges have not only like the authority, but actually the responsibility to sort of to step back and ask, right, like, well, the law is about protecting individuals from unjustified confinement, so maybe this should apply to elephants, and we think that it should, and we think that the judges should answer that by saying, yeah, these principles that already exist can and do protect elephants, in this case, from having to live out the rest of their lives in this confinement.
Thank you. That was helpful. Okay, we're going to probably dig more into all that stuff as we discuss the hearing itself. But I wanted to turn to Jake now as the attorney who argued. Can you tell us what this hearing was about, like why it took place? I think everyone knows it was before Colorado's highest court, which is exciting. But can you just tell us what were you asking for? Like and keep that part brief, but then more importantly, we want to know what your thoughts are and how it went. What did you find interesting, surprising? And then we're going to ask Christopher the same thing.
Yeah, so it's a bit maddening, but the hyper narrow ask that we were making of the court was for it to actually send the case back down to a lower court so we could continue to litigate on behalf of the 5 elephants that I discussed previously. Ultimately, as Christopher alluded to, we are seeking the elephants' release and transfer to a sanctuary as a result of the court recognizing that each of these 5 elephants have a liberty interest. All of us, simply because we are human, we are born with this interest in our country. It hasn't always been the case that we've had this liberty interest, but over centuries of litigation, advocacy, other type of efforts on behalf of disenfranchised groups of people, we all now possess a liberty interest, so we can't be arbitrarily detained. We're arguing that these elephants shouldn't be arbitrarily detained either, because they perceive the world in much the same way that we do, and that therefore they suffer in captivity. The hearing itself went about as expected. There are a specific number of questions that we always anticipate being asked, and those questions were asked of me. The difference between cases that I've personally argued in the past and some of my colleagues have argued in the past is that this case was presented in front of 6 justices, where typically we're arguing in front of usually just 1 judge. And having 6 justices ask you questions can be a little overwhelming. At times, 1 justice had not finished asking a question before a 2nd justice chimed in. And that 2nd justice similarly hadn't finished asking a question, and a 3rd justice chimed in. So as the attorney being asked these questions, it was difficult to try and get a response in for all 3 questions. So I tried my best to do that, but in the event that it wasn't possible, I kind of started with the last question because that was the most fresh, and I worked my way back. But minimal surprises as far as the material the justices wanted to cover, excuse me. But what was surprising was how intense and quick the justices got to the questions. I thought I would have a little more time to kind of lay the case out in front of them, explain answers to questions that I knew they were going to ask. But they didn't really want to hear me talk on my own. They wanted to get into the detail, and they wanted to do it immediately once the proverbial bell rang. And so it was really just a back and forth, and I did my best to establish a dialogue with these justices, have the hearing be more conversational as opposed to adversarial or litigious even. But I think all in all, it went fairly well, and I'm sure we'll hit this point later in the discussion, but just walking through the door was a victory for our organization. We got an opportunity to litigate on behalf of 5 elephants in front of Colorado's highest court, and that in of itself is a victory.
Thank you. And I just have a quick follow-up, and Christopher, feel free to ask your own or jump in however you want. When you say questions we expect at this point, could you just name a couple of those? And actually some of our supporters said the same thing in email, like they noticed that as well. So yeah, what did we expect? And then if you could speak a little bit to, you said the judges wanted to get right into it, like intense and quick. I'm curious your thoughts on what that might indicate, or why that might be.
Absolutely. Well, that's a great sign. It means our supporters are staying engaged. So I want to thank everyone who is attending this call, and for those who reached out and noticed similarities between previous cases. It's great that you've been able to follow our work to the point where you can make those connections. So that's amazing. But some of the questions are asks like, why is this case being litigated? Why don't you just go to the legislature and ask for this type of relief? We know you want a liberty interest on behalf of elephants, but what would that look like for my dog or my neighbor's dog? Would that mean that pets are entitled to liberty interests? Other questions were along the lines of, where does this theory you're arguing stem from? We understand that you guys haven't had any victories per se, so why should we be the first court to grant the relief you're asking for? And a couple other questions, but those three would probably, or three or four, would probably be the ones that we hear more often than not. And regarding the question about what it means that the justices jumped in quickly, so I prepared an opening argument about 2.5, 3 minutes, and the hearing itself was 30 minutes. I had 25 minutes to make my case in chief, my initial argument. The opposition would have 30 minutes to make their argument, and then I would have 5 minutes on rebuttal, or a bit, or about that. And so we assumed that I might have an opportunity to make a succinct opening statement. Like I said, 2.5, 3 minutes, but I think I spoke for about 20 seconds before the first question was asked. And it was asked by a justice in what I interpreted it to be a fairly hostile tone. Individuals who have watched the case, attorneys, colleagues of mine, contemporaries, they don't all necessarily agree that it was a hostile question. And I'm not even sure what the question itself was, but it seemed to me that initially the tone was fairly hostile, but that's what we expect because our cases are so novel, they're so unique. And sometimes even judges don't understand the nature of the relief we're requesting. But I think after having that discussion, establishing that rapport with the justices, we were able to maybe placate them a little bit. And the tone did settle as the hearing went on. So I took that to be a good sign.
Thank you. And a reminder to everybody, feel free to start dropping questions in the chat now, and we'll get to them in a bit. Christopher, what were your thoughts, and did you want to build on anything Jake said, or did you disagree with Jake on any point? Or
Well, to build on what Jake said about the justices kind of coming in hot, so to speak, it is unusual for judges not to let someone get through their opening statement, right? Usually it's just like a minute or two, but they didn't let Jake get to that, so they definitely came in hot. And yeah, I thought Jake just did such an excellent job handling that. So it's if you're not a litigator, it might be sort of hard to appreciate, but just think about this, right? Like it's not just like public speaking, right? It's public speaking to to these justices, right? This kind of like luminaries of the Colorado legal establishment. There's an entire room full of law students and members of the public here. I think there was like 200 or 300 people in attendance. Like it's being live streamed, and your colleagues and your family's watching, and that it's going to be recorded so people can watch it. All of you, I think probably many of you watched it, right? And then so to have these justices come in, not only are you giving this like public speech, but they have these hostile questions. And Jake just had this like very even, very professional, even keel, and really sort of diffuse that energy. And and I saw some of the judges nodding their head eventually, and you could just really feel that Jake having control and confidence over the situation, and directing the conversation exactly where it needed to be. So I just wanted to commend Jake in front of you all for that. And if you haven't watched the argument, you should. It is online. Maybe someone would be so kind as to drop it back into the chat in case anyone missed a link to that previously, and you can watch it after we wrap up here. So that's my reaction to what Jake said. And then there were a couple other moments in the hearing too that stood out to me that I could flag briefly as well. So okay. Looking at you for time. So one of them, I thought a great moment was they were sort of asking questions like, oh well, what about the dogs and so forth. And what's interesting to me about that is and what we've seen in our other cases, right, other decisions that other judges have reached, a lot of times is really a hesitation to really grapple with what that core question in the case is, which is, is it justified for us to take this this individual, right, with all the amazing advanced cognitive abilities of an elephant, right? These like long memories, the being able to recognize themselves and like have a sense that they're an individual, to even know that other individuals have minds of their own as well, right? Like they're extremely intelligent individuals, and we're keeping them in these conditions where they literally start to go crazy. They get depressed, they start to suffer brain damage. And the question is that justified? But the judges they avoid that question in a lot of ways, and one of them is exactly this, like, well, what about dogs, right? And you could say, well, someone can bring a case about dogs. You can ask, well, is this justified, right? And there's plenty of good reasons why having, keeping, I have a dog a couple feet away from me, keeping them is good and justified, and actually a very good thing, right? Whereas another captivity for another animal, like the elephants in this case, may not be. And Jake had this really powerful response where he quoted Lord Mansfield, right? This like an 18th century English common law decision that preceded our Constitution, so it's been kind of adopted by in our legal history. And Jake, you must have practiced the Latin for it, because I was very impressed by that. But it was a Latin phrase, and then you translated it helpfully for everyone, which was, let justice be done though the heavens may fall, right? Which is just, this is a justice system, so do justice. Is this right what we're doing to these elephants, right? Because our legal principles say that you have a right to be free from unjustified captivity. So like, let's just answer that question. I thought that was really strong. I think that'll age really well, and I wouldn't be surprised if, hundreds of years from now, actually people are watching that argument and reading the transcript. So I thought that was great. And I'll just say one last thing very briefly, which is that there was another point where the opposing counsel admitted that the justices did have the power, like the judicial branch does have the power to recognize that that the protections of habeas corpus are not limited to Homo sapiens, right? Because that was a question: should this go to the legislature, or can the judiciary do anything about it? And opposing counsel admitted, yeah, that the judges could do this. They could interpret the law this way, and that it doesn't have to go to the legislature. And they were surprised by that. Like, they seemed surprised that he said that. But it's so obvious. Of course they have the right to do that. The whole point of judges is to like interpret and apply the law, and especially when it's protecting individuals who are suffering an injustice, like being imprisoned against their will, right? Like that's like exactly the kind of thing that you want that judges are supposed to handle. And that, right, like, yes, the legislature could do something also, and maybe it's good for everyone to care about this, but certainly it's within the domain of judges to do, and it's a good thing. That's a celebrated part of our history, that judges can protect people from these sorts of unjustified harms. And anyways, so I was surprised that they were so surprised by that, but I thought that was actually a pretty significant moment as well.
Yeah, thank you. And I think some on our team were also surprised, because in their papers, that's not what they argue. I think they argue you can't do this, you can't, and you shouldn't. And then during the hearing, they said you can, but you shouldn't. And I wanted to share too that another of our supporters in email commented that the opposing counsel seemed to be doing it on the fly. Who knows about that? But I wondered if you could speak briefly to this one question before I shift to supporter questions, which is the difference between how we have to show up and prepare for a hearing and what our opposition does. For example, the fact that we're arguing something so totally novel that challenges the status quo in a lot of ways. yeah, we could never do it on the fly. You know, we don't have that luxury because they're the ones defending the status quo. So yeah, I don't know if I made that into a question per se, but if you could comment on that.
Sure, I can answer that. Yes, you know, what an important piece of information or context here as well is that the person that Jake was arguing against, who was defending the zoo, was actually not just some, you know, other lawyer, right? But actually the former Attorney General of the state of Colorado and also a former mayor of Colorado Springs. So he was a very well-known entity, is a very well-known entity, person in the Colorado legal community. You know, probably has personal connections to some or maybe all of the justices as well. So he's definitely was a heavyweight. And you know, in terms of the disparity, yeah, like, you know, it's easier to defend the status quo because you know, there's a certain amount of inertia, right? That's just kind of on your side. So, right, that in some ways that makes things easier. And you know, in other ways, it's also, I think, an opportunity for us as well, which is like we can approach we know where they are, right? It's a, you know, if you're thinking about it, maybe in terms of like a battlefield or something like that, like it's a position that they're holding a position, right? This kind of injustice is holding a position on the field, and we can approach it how we want, and we can sort of direct our energy, I guess, strategically, right, in a way to uproot that injustice. So I think you know, and it would be easy to just completely sort of be despondent and cynical about the fact that it's hard to change the status quo, and it you know, takes a really Herculean effort to move forward. On the other hand, there, you know, there's also some opportunities there as well, which is that, and I think a lot of that territory that's being defended is just unjustified, right? It's almost indefensible. Like how could you say that you know, that a judge can't protect an elephant from unjustified captivity? It's almost like logically nonsensical, right? That to say that the justice system can't do justice or shouldn't do justice. I mean, it's kind of wild to me. So anyways, that's some of my thoughts. Maybe I don't know if Jake has any other ones to add to that.
I think you and Lauren both touched on it. We have to show up and we have to be technically perfect. We don't have the luxury, as Lauren said, of prepping a week or two, or even just a month before the hearing. We have to prep months, plural, in advance, because the justices are looking for me and colleagues who have argued cases like this to slip up and say something that's wrong so they can dock us for that. Opposing counsel is looking for an opportunity to do the same. So we have to make sure that everything we submit, whether it's on the papers or an argument, is beyond reproach. And so that is a heavy burden. It takes a lot to get to that point, regardless of if we're talking about the written word or the spoken word. And so our preparation undoubtedly is more onerous than opposing counsel's was. Well, I shouldn't say that as if I know, because I don't. Maybe he did prep and came across as, you know, he hadn't done as much as us. But you know, personally, I worked on this case for 3 months, from the day we got the notice that we would be having arguments until the day of the argument. And that was really all I worked on, was preparation for the case. And so that's just, you know, a small example of what it takes to get ready to make the arguments we made. And I still think there's room for improvement. And so we can build off this argument in the future and make even better ones, which is great news.
Yeah, thank you. And I know you were working late into the evening, like every night. So I want to also express my admiration and appreciation for what you did, having been in the courtroom that day. It was really powerful to be there, nerve-wracking, but powerful. So thank you. Okay, I'm going to turn to supporter questions now. And I want to say too, it's great to see a lot of familiar faces and names here. So the first question comes from Julie. She's asking, why aren't we or don't we use the word sentience, or why isn't that keyword part of our arguments? Could you speak to that?
I can take this initially, Christopher, if that's all right. We use autonomy instead of sentient, because autonomy, autonomous instead of sentient or sentience, because that's what our experts use. And we really are no more than the mouthpiece for our experts. We take their science on elephant and chimpanzee cognition, and then we make legal arguments in favor of that science. Sentience is also a more wide-ranging term. Autonomy is still a fairly narrow term, and courts like that. Courts don't like to engage in these superfluous or loaded terms, which sentience or sentient, I think, would be for them. So we focus on autonomy because that's what our experts use, and that is the word that our experts have defined. And they've defined it by showing what elephants do autonomously, like plan for the future, remember the past, are informed by decision-making processes that they've undertaken or elephants in their herd have undertaken, engage in funerary practices or celebrations of life when a calf is born, things like that. And so the word autonomy is used because, again, that's the word that our experts use.
Yeah, and it seems to be the case. I'm not a lawyer, or I don't work on legislation either, but I'm going to say this nonetheless. It seems to be the case that a lot of legislation, especially symbolic declarations, can and do use the term sentience, like the burden. It works differently on the legislation side, maybe, but
if I could flag too, actually, this kind of goes back to a comment I made at the beginning when I was when I dropped the habeas corpus term on everybody, right? Which is like sort of one of the I don't know, I guess one of the challenges for us to be effective advocates is being able to communicate this to the public as well. But when you have animal cognition experts talking about autonomy, and you read the sort of the law and philosophy about why why liberty matters, or why habeas corpus even exists, like what values it's wanting to protect. It wants to the legal value is autonomy, right? So it's sort of a legal term, and then there's this question of how to translate that. Exactly. Oftentimes I'm tempted just to be like, like this seems like a very, to put it mildly, a very unkind thing to do to animals. And I think we should be a kind society, and our laws should reflect that, right? So that's a very sort of a simple way of putting it. But so you could kind of go between that and this, habeas corpus, autonomy, liberty, interest kind of legal jargon word cloud. So it's kind of a dynamic we deal with.
Yeah, and one more word on this topic. You could look at it like this, habeas corpus, or excuse me, I should start with autonomy is the foundation for the liberty right we are seeking, and habeas corpus protects an individual's liberty, therefore habeas corpus protects autonomy. I'm not certain, to Christopher's point, that you could say sentience is the foundation for the liberty interest that we're seeking.
thank you. Okay, I know we could talk about that a lot longer, but I'm gonna bundle a couple questions together now. I'm gonna take a question from Fern that you've spoken to in part. A question from Lady Nora Preston, and what's the other one? Oh, the question Howard, who sent it via email. I know you're here somewhere, Howard, but it's Fern asked, why do we feel habeas corpus is the best tactic? So there's that, and we spoke to that a bit. Lady Nora asked, would it be a good idea to use animal welfare here? And they also asked if that might have freed Happy. And then Howard had asked via email about cruelty. He phrased it in terms of like cruel and unusual punishment, I think, but there's also just the part about like an animal cruelty law. Like why do we think our approach is the right one? What about these other options? I'll put it that way.
Christopher,
you
you mind
can
if
go
I
riff off that?
I will take I'll take Fern's question. Fern, good to see you. For those of you who don't know Fern, she's a wonderful documentary filmmaker. She's a supporter of the Nonhuman Rights Project, obviously. And actually, she is Canadian. And I mention that because there's an event going on right now that's hosted by a Canadian animal advocacy group. And Fern has chosen to attend ours. So thank you, Fern, for doing that. We use habeas corpus because habeas corpus is supposed to be a case-by-case assessment. So when we bring cases, we are not asking courts to define legal rights for the entire animal kingdom. We are asking the court to define a single legal right for the individuals we're litigating on behalf of. And if the court adheres to habeas corpus procedure, it would do that. It would base its decision solely on the case before it. And that's not what always happens. Sometimes courts can't help themselves and they speculate about the far-reaching consequences of what a decision in our favor would do, but that's not the right approach. If the court takes the right approach, it is the case before it and that's it, because habeas corpus has to be case by case. In the human context, habeas corpus cases are brought by individuals who are imprisoned, and the court reviewing those cases can't say, well, okay, the individual bringing this case should not go free, but maybe prisoner B or C should go free, or vice versa. It only decides the case on behalf of the individual who brought the case. And we think that should be the case in the non-human animal context. So that's why we focus on habeas corpus. And although we get the floodgates pushback, if the court really did adhere to how habeas corpus cases are supposed to be decided, it would not engage in that floodgate, slippery slope. What does it mean for other animals analysis?
Hmm.
I call,
Yeah, go ahead.
yeah, I call this jurisphobia, right? So that's like juris is in, that's like Latin for law, and then phobia. It's like so it's a fear, basically a fear of making law. The idea that we don't want we don't want to grant justice to these elephants, in this case before the court, because they're afraid someone will bring another case and they'll have to decide whether that's justified or not. Yeah, I mean it's jurisphobia. So I would say if you're, I guess, afraid of making law, maybe consider a different profession. But anyways, that's some food
Bringing
for
the
thought.
fire.
I'm glad you laughed at that, Lauren. It was
Yeah.
Yeah, and with regard to Lady Preston's question, I'm looking at it in the chat, and I hope I'm getting this right. But we litigate for legal rights for our clients. Rights being distinguishable from welfare initiatives, because rights allow the animals to seek their own protections, whereas welfare initiatives, although they can assist animals, they're really implemented so we as humans feel better about ourselves. Welfare initiatives might look like making a tank deeper for an orca or another sea creature, making a cage slightly bigger for an elephant or another land creature, more regular feeding, variants of food, perhaps a bath, even though things like that aren't necessarily needed. So we put the animal's interests ahead of the human interest by seeking rights on our client's behalf. Welfare initiatives, they really put the human interest ahead of the animal's interest.
And if I could,
Yeah, I was just going to say Jake is also bringing the fire now at 38 minutes in. I like that, Christopher.
I was gonna add, I was gonna build on what Jake said, right, which is that the sort of welfare cruelty laws are they put human interests ahead of animal interests, and I think of like a very stark example of that is also just who can go to court in order to enforce these laws. So they're really structured primarily so that the government enforces them, right? And so that's a huge barrier, but it's the government really doing it on behalf of the public, and not even necessarily to protect the animal, right? But like with an animal cruelty law, for example, it's the sort of relief, the thing that the government is trying to do when they file an animal cruelty charges against someone is not actually to protect the animal, right? What they're asking the court to do is to criminally convict someone, maybe even throw throw that human in a cage, right? Put them in jail. And but again, that's more there's a bit of a sort of a retributive, like a like retribution sort of aspect to that incarceral approach. It's more backwards looking, and it's not actually, it's not animal centered, right? So even the kind of procedure by which these laws are enforced are also very human centered in a way that makes it hard, even if the law was being violated, to do anything about, because it's not, you know, because you can't just go to court to get a restraining order on behalf of the animal when the law is violated. It's really only the government that can do anything. So.
Yeah, and I see that Lady Preston has added a question to the chat, and I don't mean to overstep here, but I think it's a good follow-up question, so I do want to quickly address it. Welfare initiatives don't lead to freedom. Liberty interests, rights conferrals are the only thing that can lead to freedom. Now, the legislature could pass a law saying elephants will not be kept in captivity anymore in this state, this county, or even, you know, at the national level, this country. But as they're understood in the law, welfare initiatives really are no more than expansions of cage sizes or deepening of tanks, things like that. Rights allow the animals to gain their freedom in a way that welfare initiatives do not allow animals to.
Thank you. And I know Steve, our founder Steve, has said in the past that animal welfare laws can be easily overturned. It, you know, depends on who's running the show. Rights can't be. So it's not just about these elephants, but it's about, you know, future generations of elephants and all elephants. So yeah. But I take the spirit of the question to be in part like a recognition of how hard this is, you know, what the challenges we're up against and everything, and how deeply our supporters want to see our clients freed. So
yeah. And I'm just very energized by the conversation. So to add to that too, I think that's such a, you know, like inspirational and like important perspective that the Nonhuman Rights Project adds to this whole sort of animal protection space, right? Which is to step back and ask, you know, not just, I don't know, like, you know, sending a letter to a prosecutor to do something, and there's value to that for sure, but to step back and say like, well, wait a minute, like our legal system literally says that we value individuals not being unjustly confined. Like we value respecting autonomy of individuals. We want a justice system that administers justice. And right now we live in a world where animals, they're being blocked at the court, really before they even enter the courthouse, right? They're being blocked at the courthouse doors. And in a way that is actually, I think, degrading our own legal principles and our own ideals of justice. And so it's sort of stepping back and saying, like, well, wait a minute, we have these ideas, like we have a system of justice, we have legal rights that protect certain values that we find important, and so why should someone not have access to that just because they're not a Homo sapien? Right, just for that reason, right? Just simply because they're not a Homo sapien, right? Maybe they're bacteria and they have literally no interest in anything whatsoever. They don't care about their autonomy, right? So that's, but it's not because they're a different species. It's because, you're sort of looking at like who they are, what's their experience as an individual, and how does that match up with our values, right? Like that's a much more mature analysis. That's the kind of analysis we should be engaging in as a society.
Well said, I think. Okay. I'm going to bundle together now two questions from Bruce Anderson. One he sent via email and one I see here in the chat. The first one, it was actually very well written, so I kind of want to look at it on my, okay. Bruce asks first, How do you feel about the justices during the hearing never referring to the expert opinions, particularly regarding the cognitive emotive faculties of your clients? Do you have a sense that justices, particularly in this case, ever read the submissions from the experts? Joyce Poole, for example, who's one of the elephant cognition and behavior experts who submitted an affidavit. So I too am curious about that. I thought it was a good question. So that one first.
Yeah, it was disappointing that the science wasn't invoked more by the justices, especially when opposing counsel is arguing. That would seem to be the right opportunity for them to talk about the emotional cognitive capacities of our clients. But perhaps the reason the court didn't do that is because those are facts. And the factual record at the time of the hearing at the Colorado Supreme Court was already established. So the court, if it is operating in the way it's supposed to, it has accepted the facts that our experts have put forth that go to the elephant's cognitive capacities. And what we were arguing on the 24th of October was merely the procedure and where the case needed to go next. So if we're successful and the Supreme Court does send our case back to the trial court for further proceedings, which is what we want, then we will have a hearing that can invoke the facts. And if the opposition wants to try and refute our experts, including Joyce Poole, then it'll have an opportunity to present its own factual record. So, I mean, yes, you would like to hear the justices talk more about the facts, but I actually take it as a decent sign that they didn't, because it tells me that perhaps they did know what they were doing. They realized what the procedural posture of the case was, and they knew that the facts weren't necessarily pertinent for the hearing that day.
Can I want to tie that back to something I said earlier, which, in response to your question, Lauren, you'd asked, or someone had asked about the sort of the disparity between the people defending the status quo and what we do. And I said, there's actually in some ways an opportunity, right? Because the unjust status quo is occupying ground that's really, I think, indefensible. And this point actually ties to that very well, right? And that's that we, right, we select our case, we get our expert opinion, we put that all on the record, and the court has to accept that as true, sort of until they get to the point where they're actually sort of giving us like a trial or what would be like an evidentiary hearing, right? But this was thrown out before they even got to that stage of like, well, let's hear the evidence, right? Like, how smart, are elephants? What is their experience like? And is that justified? Or do they have a kind of autonomy that's being so, so severely degraded, and it's so important that we should do something to intervene, right? They didn't get that far. They had to accept everything that we said is true, right? And I think everything we said is true. But there's really no dispute about that. And like, I have the petition up right now, right? We literally, the quote, they experience permanent brain damage as a result of the trauma endured in impoverished environments. So that, I think that was a pretty powerful statement, but our whole petition is full of evidence like that. And what's kind of wild to me is that right, well, so far, hopefully, I sincerely hope that the Colorado Supreme Court rules in our favor and gives us this hearing and actually asks this question, like, is this right? Like, let's hash it out. But for courts that have rejected that, right, on the basis that you have to be a Homo sapien to access this procedure, right? You could, if that's the reason that you're being denied the ability to even file a habeas corpus petition, to even sort of to challenge your unjustified confinement, right? We could discover a new species of non-human animal, maybe on some remote island or something like that, that we could allege is actually, and experts might think is actually like, like smarter, right? Has maybe a richer cognitive experience than humans. And under this logic that you have to be a Homo sapien, like that wouldn't matter either, right? Or it wouldn't matter if you know, if the elephants were shackled 24 hours a day without the ability to move at all, and that they were literally being tortured, right? Like, you know, someone was physically injuring them every day with the intent to torture them. Like those, if you say that being a Homo sapien is the requirement to access this procedure, then what you're saying is it doesn't matter at all what your experience is like. It doesn't matter how terrible it is. It doesn't matter how rich your your experience is, that it's just going to be denied because of your species. And I mean, that's a totally indefensible position, I think. We should recoil in horror that has been the position adopted by some courts in the past.
Thank you. Bruce, if you can forgive me, I might save your question for an email that we send to you, because I'm conscious of the time here. So we're going to email you an answer to that question. Technically, we have 10 minutes left, but we can and will stay on a bit more to answer some of these questions. So feel free to stay on with us. So I'm actually going to skip down to Julie's question. Christopher and Jake, you might be able to see it there, but Julie is an activist supporting the Free Billy movement in LA. Thank you for your advocacy. And she asked, how would you defend the notion that the elephants are held captive for their, she's asking, what is our response to the arguments about that the elephants are held captive for their own good, their own protection from various dangers in the wild, survival of the species, as touted by the AZA, etc.
Yeah, I'm going to come across a little contentious here, but it's such an absurd and ridiculous position. It's hard to even organize thoughts to respond. No zoo has ever released an elephant into the wild in order to help conserve a wild species. It's a justification zoos use to hold animals behind bars. So I go out in the streets, whether I'm walking my dog or driving somewhere, I assume risks. Does that mean that I should be imprisoned because I'll be safer in a jail cell than I would be in society? I mean, what does that mean exactly when you say we're keeping elephants in prisons because there are risks in nature? It just saying it sounds ridiculous. So I think that zoos have become master marketers. They've become master manipulators. They like to greenwash what they do. They like to add a conservation angle to what they do, but it is all nonsense. It really is. I could use stronger language, but I'm trying to control my remarks here. So, I mean, you just have to call them out on their absurdities when you hear it. Until a zoo releases an elephant into the wild, then they're not really trying to help conserve a species. You can't conserve something by taking it from the wild places that it has evolved to live and relegating it to a foreign land and a lifetime behind bars. That's not how conservation works. So I think that zoos are going to have to come up with a better distraction in the near future because more people are catching on.
And I think especially with what the alternative, we actually have a sanctuary, right? So if it actually is in their interest for whatever reason to not be in the wild, then certainly if it's between, right, like a zoo with less space and less enrichment, or a sanctuary with much more space, and you know, that more enriching, that better approximates the experience that an elephant wants to have, then there's really no reason, right? Because if there's a sanctuary available, then they should be able to go there instead. It's senseless to keep elephants in a zoo.
And of course, it probably needs not be said, but they, you know, a lot of the elephant exhibits, you pay extra money for that ticket, and there is a lot of money from these exhibits, and very little of it, minuscule, goes to conservation groups that protect the elephants' natural habitats. But that, you know, even if more did go to them, it doesn't change the underlying injustice, obviously. But yeah. Okay. Anything else you guys want to say on that before I ask another?
Well, actually, I can say one more thing too. This goes back to the point about just wanting to have, like, let's have an evidentiary hearing. And that is like, if we're going to sort of Iron Man that argument, so to speak, then what I would say is I would welcome a court to ask that question, like what actually is in the best interest of the elephant. Like maybe this captivity seems unjustified. I'm concerned, but what can I as a judge do? What kind of relief can I order? That's exactly the kind of thing that the legal system is sort of structured for, judges to hear evidence and arguments about. And I'm confident that were we to make that argument, that the judge would be persuaded, exactly kind of the case that Jake laid out. So, but the fundamental point is that, to the extent that there is a concern there, then let's hash it out. Let's just go through the proceeding and do it rather than throwing the case out immediately just because of the species of the petitioner.
Okay. I feel like I'd deflate your answer in a way because I have to turn to another question. So I'm not, if I could stay on it, I would, because I'm interested. But
that's the business of the event.
yes. Okay. I wanted to say too, before I get to the next question, we're going to drop a link to our donation page and then the client page in the chat. If you want to donate, that would be most welcome. It helps. This is a long fight, a hard fight for this case and all our cases and campaigns. And so if you can donate today, that would be wonderful. But we know a lot of you are already donating. Thank you. There's that. And then I'm going to put two questions together again. One is from Wendy. I think Jake might know Wendy. Wendy asks, what impact will a win or a loss have on your case on behalf of the elephants at the Honolulu Zoo, which is another case of ours. So there's that. And then let's see, a little lower down, I hope I'm saying your name right. Jean asks, this kind of injustice is occurring across the country. In her view, the Colorado judges were hesitant to rule in our favor because they'd see it as a major precedent. And she asked, do you think there might be another court more open to making this kind of precedent decision? So I put them together because I think they both involve precedent. Like there's this case, and then how does that impact other cases, or could there be other more favorable jurisdictions? There might be room here as well to talk about Happy's case a little bit in terms of how this case builds on Happy's, or anything you want to say there. And we are going to stand a little extra because technically we only have 3 minutes left. So, okay.
I can give a quick answer to that, which is because I think there's an answer that sort of ties both of them together, which is that a very important part of what we do is just making the argument in the first place, because it's an argument that until recently hasn't been made. People haven't sort of thought outside of this box that our legal system has kind of put itself in, right? Which is right. If we value autonomy, if we value justice, then why should we withhold that from someone just because of their species, right? So just asking that question, having this conversation, is moving that discussion forward. I think a good example of that is in New York, where we filed our first case in 2013, and within sort of initially the New York Court of Appeal, the highest court in New York, didn't want to take any of our cases. They were happy. They were happy for lower courts just to dismiss the case and then to not have to worry about it. But over time that started to change, and I think it's because it went from being like kind of a startlingly new idea to one that had started to resonate. Like it was maybe a little less fearful about it, more acquainted to it. And then we had I think in 2018 we had a concurrence from a New York Court of Appeal justice in Tommy's case, Justice Fahey, who said, for procedural reasons, I don't think we should take it, but because we rejected this in the past, but like I actually think this is a question that we should take up and answer. And then of course Happy's case was a couple years later, and the New York Court of Appeal did take that case, and even though we lost, there were 2 of the 7 justices wrote opinions in our favor, right? So what this is telling me is that this is an idea, that this is a discussion worth having, and that the more we can have this discussion, the more we can sort of build traction and attract more judges to this, right? They're going to be less afraid to go along with this, the more acclimated that they get. So I think that's how this case can affect Hawaii, and I also think our lawsuit in Hawaii for the elephants at the Honolulu Zoo, and yeah, and I think sort of the more we do this, and the more ice that we break around this, the more likely a court is to rule in our favor.
And is it?
Yeah. Oh, sorry, Lauren.
Yes, one question real quick. Is it correct to say that if a court didn't rule in our favor, it doesn't preclude a court in another state from doing so?
Yes, and it does not even preclude a court in that same state from reconsidering that decision, down the road, or considering maybe sort of an alternative theory, right? Something that might legally distinguish a future case from one that they decided. So, it's fluid, right? The law is supposed to be responsive to circumstances, and we know so much about the experience of, chimpanzees and elephants and other non-human animals that courts can and should make sure that our legal principles are being tended to and updated to reflect what we know.
Thank you. And Jake, what were you going to say?
Yeah, I just wanted to piggyback off of what Christopher said quickly, because I think, and I apologize if I'm pronouncing your name wrong, but Ida has asked a few questions that go to what Wendy was asking as well, which is kind of what are the implications of a victory, and how do you reconcile those implications with the fact that I said habeas corpus was inherently case by case. And I think Christopher did a good job of explaining how our cases can inform. But maybe another way of saying it is habeas corpus is supposed to be case by case. So in theory, whatever happens in Colorado should be irrelevant to what the Hawaii courts do. The Hawaii courts should make their own decision based on their own state law. The courts in their respective states should be separate and apart from one another. Now, of course, courts will look to one another for guidance when they're dealing with novel issues, in the same way that we, as independent humans, look to one another when we're dealing with questions that are very challenging and that we don't have the experience in our own lives to fall back on. So we're trying to normalize this argument, but at the end of the day, when we get into the technicalities of the lawsuits, these cases really should stand and fall on their own. And unfortunately, they don't, because courts look to other states and say, well, relief hasn't been granted there, so we can't grant relief here. If we're successful in winning our first case, maybe courts will say relief has been granted there, so now we are going to grant it as well. And we might be able to flip the narrative as a result.
Thank you. And thank you for gathering those questions up in that way. It's very helpful. Okay. I have one more question from the chat. And then I want to talk about Happy a little bit, because the webinar isn't about that, but I want to speak to the concern there. And then, yeah, so now's the last chance to get some questions into the chat, and then we'll have some closing remarks after that. So the question has to do with the fact that we refer to our clients as individuals, and I think it was Valerie was saying, she noticed that and wondered if we're deliberately not referring to them as persons, which I don't think is the case. But she also asked, what are your thoughts on the possibility of your clients being recognized as non-human persons? And she also points out that who's recognized as a person has changed over time, with corporations now recognized as persons. And someone over email asked, why not, if corporations, why not animals? So who wants to take that big question?
I can jump in. Justice Ginny Rivera of the New York Court of Appeals asked the same question in her dissenting opinion in Happy's case. So, we also wonder why, if corporations can have legal identity, why can't our clients? So it would be technically incorrect to say that our clients are legal persons today because they have not been conferred a right to liberty. This is complicated, so if none of you follow what I'm saying, I don't blame you, because it's taken me many years to even get to the point of being able to talk about it. But being a legal person just means that you possess at least one legal right. So corporations are legal persons. Humans are legal persons. Perhaps some non-human animals are legal persons because they are trust beneficiaries. So they have the legal right to the corpus of a trust. So if we are successful with our litigation, say in Colorado on behalf of these 5 elephants, then they would become legal persons as a consequence of possessing the legal right to liberty. Until they have that right, we can't really call them persons, so we call them individuals. But we would have no problem in calling them legal persons if conferred that right. It's just a matter of semantics.
I do think it's a semantic thing that can be really confusing too, because in our sort of common vernacular, if you say like another person, most people just sort of like mentally are just thinking about another human right there, and that's one of the reasons why it's surprising to think about corporations as persons, right? Because you're like, oh, that doesn't quite seem right in the way that we use the kind of like the everyday use of the word. But yeah, and exactly like Jake said, in the legal sense, it just means you have some legal rights or obligations, and it doesn't dictate what those rights or obligations are, right? So even though corporations are legal persons, they don't have a right to life. You can kill a corporation. The Nonhuman Rights Project board of directors could vote as soon as this call ends to dissolve the entire non-human rights corporation, and they're not going to be right. They haven't violated any rights necessarily by doing that. In the same way, like this sort of the profile of legal rights, even among different humans, can matter based on like, are you an adult or a child? Are you under a conservancy? Are you are you a citizen of that state or country, or are you a convicted felon, right? Like all those things matter. So it's really, the question is just kind of like it's like what legal rights should they have, right? And that could be sort of more of a case by case analysis.
Because what sort of rights should you have? You answer that question, and then you become a legal person just by getting the right.
Yeah, so instead of asking, are you a legal person or should they be a legal person? It's really sort of working starting backwards, right? Or in the way we would normally think about it, and say, well, what rights should this individual have? And then once you do that, like that, you've defined what kind of a legal person they are based on that.
Mm-hmm. Right. Yeah. I was just thinking about how Steve again had, like, he drew that hard line between you're a person, you have rights, your thing you don't. Like there's the person thing distinction. And we talked a lot about that the first, I don't know, 5 years of our litigation. But that's also just a way to help people just see the problem, rights are what we're after, but talking about thing versus person is a way to just see there's a problem in the first place too, I think.
Yeah, because it gets to this, it's this idea of this like indefensible space that is the status quo, which is to say that unless you're a Homo sapien, like if you're not a Homo sapien, you have no legal rights whatsoever. Like you're not going to consider it like sort of in any context. It doesn't matter. It doesn't matter how much that otherwise sort of like degrades our the values of our legal system that cares about autonomy and cares about freedom and not torturing someone, not keeping them in a dungeon against their will. If they have if that's negatively affecting them, right? So the yeah, anyways, so it's just kind of this other question of like, well, what legal rights should they have? And like, let's be open-minded to the fact that that an individual can have an experience, even if they're not a Homo sapien, where they should have legal rights and like where they matter.
Thank you. Okay. I wanted to just say briefly about Happy. There's some people asking about Happy, our client Happy in the chat. It is our understanding that Happy is still alive. We'll have an update soon, I believe. I believe it's also the case that a rally is being planned for January in conjunction with the Vigil for Elephants. More on that soon, I hope. It's still being worked out. And I wanted to thank everyone for their advocacy on behalf of Happy, not just the last few difficult months, but over a period of years. We understand how frustrating and upsetting it is. I guess the question I wanted to turn to Christopher and Jake, and I invite you here also for any final remarks, is to speak on that difficulty or how slow it can be, how long it can take. You can approach that subject however you wish to, whether like how you deal with it personally or how you account for that difficulty. Yeah, and so yes, I'll end that question there. How about Jake goes first?
Sure. Yeah, I appreciate Ida's follow-up questions. These are really good. And I'm thankful that you are participating in this conversation, not just, passively watching, but engaging with the material. A wise man once said, the moral arc of the universe is long, but it bends towards justice. I mean, litigation takes a long time. Unfortunately, this is going to be a fight that takes all of our lifetimes. And at the end of those lifetimes, we may not see the change that we hope to see, but we will have laid the groundwork for future generations. And ultimately, hopefully that groundwork leads to abolition for our clients and other non-human animals. I wouldn't characterize our work as minimal or only seeking protections for one individual as opposed to a whole species. Although that is in application what we are doing, it is what we are doing because we have to. We have to be able to establish a precedent in order to move forward. It's impossible for us to litigate on behalf of an entire species, even on behalf of an entire species of non-human animals in a single state. For example, we couldn't bring a case on behalf of the Cheyenne Mountain Zoo elephants and the Denver Zoo elephants and ask for the relief we asked in our case. We have to take this by individual cases, and hopefully over time, those cases will start to become victories, and this will snowball into not only efforts by the Nonhuman Rights Project, but others as well, and not just litigation efforts, but legislative efforts too. So I appreciate that it is a long fight. I appreciate that people can become restless. I myself become restless, but just know that we are doing everything in our power to create change. But change, unfortunately, it happens very slowly, especially when you are talking about groups of individuals who do not even look like us. And so the fight is a long one, but it's one we plan to wage continuously. So I appreciate everyone for attending this webinar and for your continued support. It really does mean a lot. And we think about our supporters all the time.
That's true. I know I personally take great energy from our supporters, or rather their when I hear from you all via email and otherwise, like it helps keep me going. So please keep sharing your thoughts in that way. Christopher, what would you like to add?
Yeah, I mean, sort of, fighting against systemic injustice is hard, and it does take a long time. So I one analogy I think about a lot is the marriage equality movement, and something that I learned pretty kind of recently actually was that in the 1970s there was actually a case that went up to the Minnesota Supreme Court about the right to marry someone of the same sex, and they lost that case, and then even asked the U.S. Supreme Court to weigh in, and the U.S. Supreme Court said there's no federal issue presented by the right. They denied it, and they said there's not even a federal issue presented by that. And that was in 1970. So, but what happened afterward, like after that, right, was sort of this like steady arc of progress, right? There was a case in the 80s, or no, it was in the 90s, two cases in the 90s, like one that said that you can't just sort of discriminate against someone purely on the basis of their sexual orientation. And the Hawaii Supreme Court, under that state constitution, actually found that there was a constitutional right to marry. That was in the 90s, and then there was like some backlash and a little more progress in the 2000s, and then of course in 2015 it wound its way back up to the U.S. Supreme Court, and that there was at that time the U.S. Supreme Court, they did a total 180. They said there is a federal question here, and the federal question should be answered in favor of marriage equality, right? So that was for 40, 50 years, and a lot of justice movements, they take a while, and it's just it's difficult to make change, but it's important to be applying that energy to challenging the injustice, to really spreading the word, educating people, which is really the primary goal of this conversation, is to engage with you all and help spread it that way. So yeah, I mean, really, it's just about, it's in some ways it's an endurance test as much as it is about the strategy of exactly what case are we going to do, and exactly where are we going to file it, and exactly how the kind of nuts and bolts of how that's going to work. There's a big endurance element to it as well. So I think this is, what's going on here is really important. I think it's inevitable that we're going to win, because the status quo is so unjust and indefensible for a lot of the reasons that I flagged earlier, right? It's not just humans who matter. So I guess thanks for being our supporters and engaging. I think we'll sort of shamelessly drop our donation link again. if you want to donate, we definitely do need the support. I think we're a good bang for the buck, but even if you can't, that's okay too. I'm glad that you're engaged at all. So
Yeah, thank you. And I'll add, if you can't donate, sharing our client stories is extremely helpful. Raising awareness of their plight via their client pages or sharing social media posts. Yeah, that is helpful always. And I know a lot of you are already doing that. So I see Terry's asking, will there be a replay link to share? Yeah, we recorded this. Hopefully the recording will have saved in the cloud, and we will post it in our YouTube channel in the coming days. And I see some thanks to us in the chat. Thank you. The thanks is all ours. Thank you all for being here. Yeah, we're gonna conclude now, about 17 minutes later than planned. Thank you again for your time and interest and thoughtfulness, everyone. And we'll have another one of these soon, I hope. Yeah.
thank you. Thanks for I don't know, facilitating, Lauren, and thanks Kelly and Jake and everyone for your questions.
My pleasure. And Christopher's, I saw a little friend walking behind you. I don't know who that was.
Yeah. Oh, that was Nico. It was just one of my dogs.
Okay, great. Yeah. Yes. Okay, we'll close it out with Nico then. All right, take care, everybody. See you soon.
Bye.